So, you guys might have noticed that Apple announced the new iPhone 7 last month, and Anthony Weiner said, "How's the camera?" So, I was told that if I agreed to speak, that you guys had a very flattering picture of me that you were going to show. And so, bring up. Yeah, that's my volleyball. Yeah, all right, so here's the deal. Lawyers use shorthand. We use terms. We say stuff. We know what it means. But do you know what it means? Now, some of the terms we're going to discuss today, you know. Some, I'm going to guess you don't know. And some, you might kind of know, but not sure what they are. So the idea here is to discuss lots of terms that perhaps no one ever told you what they meant. So I can talk, and those of you who know me know this without a doubt, I can talk for an hour and a half, nonstop, and just bullet points. And about 8 minutes in, you guys would start getting loggy from that great breakfast and tune out. So to make it more interesting, a lot of the topics are going to involve trivia. Now, it's fun to do trivia. I like music trivia, cultural trivia, oldies trivia, movie trivia. People, when sometimes they do trivia, say, well, I don't know a lot of law stuff. Yeah, none of it's law. There's no law trivia. This is all culture trivia. But it's nice to win. But shouldn't you win something? And so I'm going to sweeten the pot a little. Okay, ready for the next slide. Because when you get a trivia question right, you get two. You're going to get prizes. So the wonderful and fabulous Anne McGinn has a bag of candy, packages of candy, and a bag of tchotchkes, little party favors, horns, please don't play the horn, puzzles, tops, Groucho Marx glasses, and if you get a trivia question right, I will send it to you, and it's ready, got her track shoes on. You get to pick one from either one. You don't get two, you get one. Okay? Those of you who are into candy, great, you love the candy. So it's high quality candy. You don't like the candy, or you're on a diet, or your sugar makes you, whatever, you can pick that toy. You can pick either one, but you only get one. Everybody understand it? Okay. Some of the trivia is going to be kind of easy. Some of the trivia is going to be really hard. Okay? And everything in between. All right? So in between the trivia, I'm going to kind of sneak in some what the term means. That's kind of what's driving this. Okay? So the first thing we're going to do is to a blank. Okay, thanks. Stop. Hold it here. Okay, here's the first trivia question. Now, and let me just say this. If you yell the answer out, the person next to you will win. Raise your hand, let me call on you. Do you understand? Don't yell out the answer. Okay? Unless you want your friend to win, then that's fine. Okay, you understand? Okay. So, I would like you, many of you have much experience in criminal, to tell me what motion is made in criminal cases more than any other motion. In fact, I think I could make a successful claim that it's made more than all other motions combined. What motion is the most common motion made in criminal cases? Okay, let's see hands. Okay. Continuance, you got it in one. Okay, wait, you get a prize. And run. Prize. Okay, if you clap every time someone gets it right, we'll be here for 6 hours. Okay? There's going to be a lot of trivia questions. I did this yesterday with my paralegal who said 9 out of 5, 53rd. I'm like, the continuance, 1050 is, there's a million more of those than all other ones combined. Now, that was a pretty easy question. Now we're going to have a little tougher question. Did you already get the prize? Did you pick something?
Yeah.
Okay. Show them what you picked up. What is it? Is it candy? Mike and I love Mike and I. Okay. All right, so here's the next one. I want to know who this is. Who this is. Don't yell. Put up your hands if you think you know. Tom Gillet, who was Speaker of the House for a while, disgraced. Okay? Now, we're not going to do this all the way through, but just so you get a sense, when you pick what you hold up what you picked so we can see it, okay? All right. So, why is he here? Okay, next slide. So 1050, you hear people say, I'm going to do a 1050. I've got a 1050, I have 10 1050s today, I have 50 1050s today. Okay? These are all motions to continue a case. And of course, the goal of the continuing the case is to delay the case, or as we call it, Tom delay the case. Some of these are just puns, okay? But that's what 1050 is. You'll hear people refer to that. Okay, so the next one. Now, there's only going to be a couple of political things here, okay? I'm trying to not take sides here, but the next thing we're going to cover is 170.1, which is challenges against the judge for cause. As you may remember, a couple of months ago, Donald Trump accused a federal district court judge of being biased and said he should recuse himself because he is presiding over the Trump Foundation lawsuit and he is Hispanic, of course, born in Indiana, but he's Hispanic. And since Trump wants to build walls on the poor people, therefore, the judge is biased. Now, here's your trivia question. Let's see if I can stump the room. Name of the judge. Oh my God. Do you know the name of the judge? Wow, say it loud for everybody here. Wow, I thought no one in the room would get it. Shows you what I know. Congratulations. Okay, good. So, anyway, essentially what Trump is doing is making a 170.1 motion. And you hear people refer to this. I had a call on it the other day, and it's that the judge is biased, actually biased. The judge hates me, hates my children, hates my family, hates my client, and therefore can't be fair. Okay, these are not done a lot because we don't win them a lot, but you may hear it referred to. I had a call again the other day. Okay, the next one is 170.6. You'll give this a lot more. There's no trivia questions, just a goofball picture. This we refer to a peremptory challenge against the judge. I'm affidaviting the judge. You'll hear the verb affidavit. It's not a verb. The noun affidavit being used as a verb. I'm affidaviting that judge. Judge Smith, I'm affidaviting that guy. I hate that guy. Okay? So this is a 170.6. These are Code of Civil Procedure sections. In a criminal case, in every case, the parties each have one challenge, automatic peremptory challenge that kicks the judge off the case. Like in jury selection, we kick off jurors, okay? Well, you get to kick off one judge. Each side has one of these per case. Now, in the real world, occasionally we talk about the real world, the criminal defense bar is very reluctant to use these because when you use it, they find the worst judge in the entire Western civilization and they send you to that judge. So you have to ask them if you feel lucky. You're getting rid of bad judge, going to horrible judge, okay? So we're not using them a lot, but you'll hear the verb is affidavit. You'll hear people use that. Okay, hold on a second. Oh, I know, okay. Trivia. Let's do some music. Excellent. When I did this talk previously, I called the talk 995 ? Mark down from 10. It's a little early, they didn't get it. Okay. Here's your trivia question. Okay, you have to name, to get to win, you have to name all 4 actors here. So, and I'm not going to help you when you say, blah, blah. I'm not going to say yes, 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 no. So I'm not going to give any hints here, okay? You have to get all 4 in order to win the trivia, okay? Anybody want to take a crack at it? A couple of them should be pretty easy, okay? Nobody else wants to put up their hand? Okay, so say all 4, go ahead.
Dolly Parton.
Oh, I thought Dabney Coleman was going to be a tough one. He had trouble with Dolly Parton, who was singing. Congratulations, another prize. And run, and. Okay, so you hear this referred to a lot. Clients want 995 motions in situations where it doesn't even apply. The 995 motion is a motion made after the filing of the information post-preliminary hearing. And the defense has a right to make a motion to dismiss. And there are 2 grounds for the motion. One is lack of evidence, insufficient evidence. And the other is what we call denial of substantial right, which is that the defense was improperly cut off on cross, or there was some other violation of law other than sufficiency of the evidence. You'll hear this referred to. I'm going to make a 995 motion. My 995 is next week. My 995 is on the calendar now. It's a motion to dismiss the charges in a felony case post-preliminary. Okay. Now, there's another motion which you might have heard of. question. Who is this? This is an actor. Oh, maybe the audience doesn't know who it is. Do you not know who it is? Okay, wait. Don't yell. Put up your hands if you think you know who it is. Get somebody here. Wait, come. I see hands. Nobody knows who it is? He was in Big Love. Does that help? Oh, Ann, you think you know? Harry Dean Stanton. Ann and yourself? A prize. It's Harry Dean Stanton. Next slide. So you will hear this referred to, it's a Stanton motion. It is not about Harry. Just FYI, it's not about him. What it is sometimes, okay, so a 995 motion is limited to what happened at the preliminary hearing. Well, what happens if there was something wrong, but it didn't happen during the prelim, like say a discovery violation that only came to light later? So the cases have created a kind of approach to this. It's kind of like a 995, but it's not a 995 because it's not what happened during the preliminary hearing. So the case that created this is called Stanton, so we call it a Stanton motion. So a lot of times lawyers will combine 995 and Stanton motions, and sometimes that's appropriate, but they're two separate concepts because one has to do with what happened at the prelim, and the other is what happened other than that at the prelim. Okay. All right, so I don't have a trivia question for the next. This is the 991 portion. I have to say that I heard the other day, I was at a party in Hollywood the other day, and it was a discussion about the meaning of life, and the term Porsche came up several times during the conversation. So 991 motion is a motion in a misdemeanor. 995 is a felony, stands a felony. 991 is a misdemeanor, and if the defendant comes in custody, the defendant can make a demand or a motion under 991, and if there's insufficient evidence, the case has to be dismissed. So this is a misdemeanor equivalent to a 995. Our lawyers, if they're listening to me, are making 991 motions a lot in misdemeanor arraignment courts. There might be a high volume of those. Okay. I think they're getting bored. We need to do a trivia question. So I want to know, you're going to have to get the name of the song and name of the performer on the next one. Go. Wait for it. Yelling out stuff is not smart. All right, anybody going to take a crack at it? Anybody? Okay, back here, I can barely see you in the light. Go ahead. Ooh, say it.
Crazy Train, Ozzy Osbourne.
Okay, Crazy Train, Ozzy Osbourne, and sprint in. Very good. So this is. Oh, yeah, next slide. I had the answer, okay. So 1368 is a penal code section that deals with this issue. The defendant is not competent to stand trial right now. Now that's different than not guilty of arson and insanity, which I'm going to cover separately. This is today he's not competent. He might have been competent back when he committed the crime, allegedly. Okay? But today he is a raving lunatic. Or some people think that describes me, but so the defense declares a doubt about the defendant's competency, and a hearing is held, sometimes a jury trial is held, on whether the defendant is competent to stand trial right now. We use the word insane, it's not the right term. Incompetence is the term, really the term of art. But the shorthand is 1368. Well, I'm not 1368 this client. Well, the client's 1368 proceedings are set next week. Well, he was found 1368. Okay? So the issue is whether the defendant is competent to stand trial right now. That's what a 1368 section refers to. It can refer to the hearing itself as well. All right, so next is not a trivia question. I'm going to talk about appointment of counsel, which includes my office of public defender. I have a comic here from 1957 for 10 cents called Public Defender. And the public defender's on the right of the foreground. And I don't know what's happening in the courtroom, but I want you to notice that the public defender is pulling a gun. Because, sometimes we have to take care of business. Is that a bizarre thought? Anyway, 1957 comic. So, the court, when a person is charged with a crime, they can hire their own lawyer or they can represent themselves. If they are too poor, if they're indigent, they can ask the court to appoint them. The section governing this is 987. Now, my office, public defender's office, gets appointed. Sometimes we have a conflict, APD gets appointed, sometimes they have a conflict. there's conflict panels around the county, ICDA downtown, and there's all kinds of stuff all over the place. You will hear people talk about 987 lawyer or 97.2 lawyer. Those are people who are private lawyers appointed by the court because there's a conflict. Okay, the theory of the system is that the public defender's office is appointed first. But if we're unavailable or have a conflict, then the alternate public defender, then private lawyers. But you'll hear the reference to 987 lawyers, and that's a reference to a private lawyer who was appointed by the court to represent an indigent criminal defendant because we had a conflict. That makes sense? Okay. All right, next is, 97.9. I'm going to talk about death penalty. Since I have a captive audience, I thought I'd recommend a book. People keep saying, I'm a big reader, I publish book reviews and such. People say to me, what's the best book you've read in the last year? The best nonfiction book I've read in the last year was Brian Stevenson's book, Just Mercy. And I have to say, I thought this would work, and it did. I got the CD audio, I got it out of the library, and ripped it and listened to it in my car. Brian reads, now I'm not friends with Brian, but I've seen him speak. If I say he's the most articulate speaker in the country, then that make me number 2. But anyway, he's fabulous. And listening to him read this, it's a story of one of his cases, but a lot of it's his life and a number of his cases. But he follows one case mainly. And I remember arriving somewhere, and I couldn't get out of the car because I had to hear whether he got a stay from the governor to prevent the client's execution. And of course, it happened 15 years ago, right? But I could not get out of the car. This is a compelling, fabulous book. One of my great, some of you might know this person, one of my great former law clerks now in APD, Lisa Kang, took Brian Stevenson's class at NYU in law school. She said in every class, she cried, okay? This story will make you cry. It's not a story, it's true events. And it's primarily, he practices in Alabama, Georgia, where people actually get executed a lot. And he's trying to prevent that. Some of those people, happen to be kind of innocent, but that doesn't matter to the system. Brian has done great work, and the book is a phenomenal, fabulous book, so I highly recommend it. So 97.9 is the code section that authorizes a judge to pay for experts or anything else that the defense needs in a capital case. So when my office handles a death penalty case, there's a special statute governing, we can ask for a fetal alcohol syndrome expert, or it doesn't have to be an expert, it could be a test on blood or something, right? Whatever, it could be actually a reconstruction expert. The funding for that is through this code section 97.9, and you'll hear people say, I'm making a 97.9 motion, or I got 97.9 money for this, and that's a reference to use of the death penalty statute, this statute 97.9, to get funding for in the death penalty case. Okay. Next is 1535. I'll read you the comment. This is the Missing Persons Bureau, and the lady says, call off the search. I don't miss him anymore. So you probably all know 1538.5. 1538.5 is the code section that allows a criminal defendant's lawyer to make a motion to suppress evidence for illegal search and seizure grounds. Now that's different than Miranda. We're going to cover Miranda separately. But this is illegal searches, basically. So you're probably all familiar with the term. However, there's some things about 1538 that I'm going to cover that might make a difference. You got handouts. Is that my handout? Is that what you got? Is that what you guys just got? Yeah. Okay. So I realize people are taking notes, and the whole goal of the handout was so we can take notes. We didn't quite mention that here. But. Okay. So the first thing we're going to do is this. So this is, next slide. All right. For the trivia on this one, I know you're getting bored, you want more candy. Okay, so for this one, you're going to have to do 3 things to get this. You're going to have to get the name of the actor, the name of the characters he's playing, and the name of the movie or series. Okay? I need 3 things for a win here. Okay, ready to take a crack at it? The back of the room hasn't won much. Back of the room, anybody in the back of the room think they know this? No? Boy, I thought this guy was famous. You guys knew Curiel, but you don't know this? Wow. That's your guys, yeah, well, okay. Okay. Looks like the room is having trouble with it. You want to guess? Go ahead.
Well, the Rock, I think his name is Sean Johnson.
Okay, well, that was, I'm not sure I can get much credit for that.
All right.
That's it?
I really have to practice.
Okay, well, it's Dwayne "The Rock" Johnson. You know what? I'll give you credit for if you can figure out what movie series this is. Anybody take a crack at that? He's in this series. That's why he's up there. Right in the back of the room. Say it. Fast and Furious. It is. Ann. Where's Ann? Okay. And the character. Here's the reason he's up here. The name of the character he plays. Everybody know this? This is the point of the thing. Nobody knows? Okay. So he's Luke Hobbs. That's the name of his character, which is relevant because, next slide, we're going to talk about Hobbs warrants. You see how beautiful that was? I couldn't come up with a good one for warrants, so I went with Hobbs. Okay, so I had a call on this the other day too. There's this weirdo procedure, this is really weird, where the prosecution claims that they can't disclose their search warrant information because it will endanger somebody or whatever. And so they want to do it in secret. And the Supreme Court, in a case called Hobbs, said that they can do a secret procedure. Here's the procedure. I'll give you the whole procedure. I had this call just the other day. The judge reviews to see whether it's appropriate to keep it secret. And if it is, which is, we always lose. The judge then reviews the defense moves to quash and reverse a warrant. And the judge does the defense job for them. Quashes, reverses, and then rules. And guess what? We always lose. Okay? But it's a secret procedure because we're not there. And you're definitely not there. Where the judge reviews a warrant that for some reason has to be kept confidential, or is claimed to be kept confidential. So you'll hear the reference to this you'll be helping the lawyer talk to the client. It'll be, okay, here's the search warrant. Here's what the search warrant says. I, Joe Schmedlap, am a police officer with 20 years experience in the police department. And then 3 pages of black. And then please issue the warrant. And the client's going to do, what are they saying? It's a secret. Okay? So you understand there's a whole procedure for this. We're fighting the procedure, whatever, but it's being done, and the case is Hobbs, so they're called Hobbs warrants. Okay? If you like that, you like this. Okay. Here's the book I'm actually listening to on CD audio right now. I don't know if you know Bill Bryson, who's written some travel books and some other really interesting books. So the new book he has out is called One Summer, America 1927. I highly recommend it. Very interesting stories about a lot of stuff that happened in 1927, the 1927 Yankees, Lindbergh crossed the Atlantic in December 27, all that stuff. But one of the things he does is tell a story about an origin of a term. Now this turns out it's somewhat in dispute, but I'm going to tell you the story. So in the early 20s, in the early part of the century, baseball was having a lot of trouble monetizing. They were having trouble figuring out how to make money. So they never had this idea. A guy came along with the idea, you're going to laugh, of selling food at the baseball games. Nobody had this idea. And the owners didn't have the idea. So they let this guy, at a small amount of money, set up concession stands. The guy became a millionaire. The owners were still trying to stay afloat. So the guy who came up with the concession stand needed food that would last a while, because we're buying it here, right? And then we're bringing it all the way over there, and then we have other food. So the food, you know the McDonald's fries, by the time you get them home, they're shitty. Okay, I shouldn't say. I apologize. They're no good, right? Because 15 minutes later, they're cold and useless, right? So how do you keep the food going? So he tried different foods, and the food that worked was a sausage in a bun. Worked. So the New York Times wrote an article about this, sarcastic article, just disparaging this horrible food, and they tried to imply what was in the sausage, what meat was in the sausage. So they called it, get ready for this, a hot dog. And that's where the term came from. Now that turns out that it's controversial whether that's really it. Bryson tells the story very, very articulately. And the reason that you're looking at that is because of Frank's here. Hot dogs, Frank's, got it. Okay? Yes, a little step there. So, in one of the things that happens in a 1538 fire, or could happen, there's a case called Frank's. So, the search warrant, not a Hobbs warrant, alleges facts. The informant saw the defendant sell drugs, and he has drugs in his house, and he's, whatever. There's an allegation of facts. Sometimes the defense disputes the facts. They're like, my guy doesn't even live there. He was in Ohio at the time, right? So how do you have a hearing where you dispute the facts? Well, it's called a Frank's hearing. A Frank's hearing is a hearing where the defense challenges things in a search warrant affidavit as being untrue. And both sides put on evidence, and the judge decides what to believe. If the evidence is, if it turns out some of the statements aren't true, they get subtracted, we see what's left is enough, blah, 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 blah. Okay. Next is rating warrants. So I have a goofball cartoon of a police officer with a warrant. Okay, you'll hear this term, rating warrant. So the police can get a search warrant, and they can go to your house and search your house with a search warrant, right? That's what a search warrant is. It's authorization to search a house. What if they want to arrest you? You don't really care about searching. They want to arrest you. Okay? Now, if you're on the street, you're under arrest. What happens if you're in your house? So the Supreme Court of California has said they can arrest you in your house, but they need a warrant. Now, if you just shot somebody and they're chasing you, they do not need a warrant, okay? Just in case you're thinking through how to get away with the crime, you're watching how to get away with murder. You know, my wife's watching that. I'm not sure how I feel about that, right? You can't do that. But the police, other than some exceptions, can't just go in your house to search, to arrest you. What they need is a warrant, and it's a warrant of arrest. Now, we usually just think about search warrants, right? That's always a search warrant. But there is a way to get a warrant to arrest inside a house, and it's called a Ramey warrant, named after the case warrant. No, Ramey. Okay? There's a case called Ramey, and therefore we call them Ramey warrants, and you'll hear that referred to occasionally. All right, so if you go back, you got to help me direct, because when you go back, then I have to hear it again. So go ahead. Here's the next thing.
Sorry.
No? It's not a trivia question. You got the answer. Listen to it for a second. Okay. Anybody ever heard of this group, Lutenberg Klug? Okay. So just so you know what they are an Austrian pop duo from Styria. Their style fits in well. This is from Wikipedia. Their style fits in well with the Austro-pop movement lying somewhere between pop and rock. From Wikipedia. But anyway, you heard a little clip of it. Has anybody ever heard of this kind of stuff at all? Okay, I haven't heard of it either. There's some international stuff that you're going to hear about today, just because, you know, I'm trying to be cool. Okay, so Lutenberger motion. So that seats Lutenberger. Okay, terrific. All right, so the search warrants often include claims from an informant, a confidential, reliable informant. It's amazing. They're always confidential and they're always reliable. Okay? So, when the defense raises a doubt about the informant's credibility, the Lutenberger motion allows the defense to get information about the background and reliability of the informant. So it's a motion to get information about an informant used in a search warrant. It's called a Lutenberger motion. Okay? Now, next, ready for some trivia? Okay, here's the next one. So this is legitimate expectation of privacy in their research. I call it enigmas. So, to win this, you have to get both. Name of the actor and name of the person that the actor is portraying. You need both for a win. Come on, back to the room. Come on, win something. There's candy here, getting older by the second. Wait, don't yell. Put up your hand. Put up your hand. You can't win if you yell. Okay, let me back to the room. Come on, back to the room. Okay, way back. Say it. Say it. Talk. Okay, so it's Joseph Gordon-Levitt, who the rumor is lives on my block in Silverwood. We haven't seen it, but that's the rumor. It's Joseph Gordon-Levitt on the left. And did you get okay? And this is everyone's on the right. It's actually not a bad comparison, I think. There's a movie. Oh, a movie. There's like three, aren't there? There's a documentary. The Gordon-Levitt one was not a documentary. It was a movie. I think there might be 3 movies about this. Something, a lot of movies. So, for whatever it's worth, I coined the term LEPAs. It's a legitimate expectation of privacy in their research. You will hear the word standing, which turns out to be the wrong word. So, a criminal defendant, in order to challenge a search as being illegal, if you get searched, I can't challenge your search. I have to be searched. Now, not literally, I have to have some interest. Okay, so for example, let's see if I can do this without getting into trouble. Okay, so here's my name. Here's my name tag, okay? Name tag. Okay, could you hold it for me? Okay, so now, when they seize it from her, I have an interest in it. Do you see? Okay? So it's a little complicated as to when this happens. The lawyers and the judges and the DAs use the term standing. The defendant has to have standing to challenge the search. It turns out it's not the right term. The U.S. Supreme Court has said it's not the right term. I'm going with them. And the right term is, catchy, legitimate expectation of privacy in the area of search. Rolls off the tongue. So I invented LEPAs, legitimate expectation of privacy in the area of search. And once in a while, you'll hear one of the lawyers in my office say LEPAs, because I keep saying, say the term. I say to the lawyer, sometimes the client does not have standing in a technical sense, but does have LEPAs, and vice versa. So sometimes you might lose because you have the wrong term. Don't do that. Use the right term, and then try to establish how your client has LEPAs. Okay? I'm saying yes. Wait in the back.
Can you give an example of a case where you're standing, like where you would win because of the
Yeah, okay, I'll do it again because I just had it. Okay? So, you want to help me? Okay, you're gonna take this from me, okay? Here's my name tag, okay? She took it from me, okay? I have LEPAs in my in my name tag, right? And even better, I did this once where I put something in my pocket and of course I picked a gal and then we got into trouble, so I'm not doing that. But I'm just saying, it's in my pocket and she came into my pocket to search it, then I would have LEPAs to challenge the legality of the search. Does that make sense, everybody? Now, I'm going to give it to you. Now you come over and take it from her.
Give it to me.
When you make her a pretend police officer, she just goes right into the mode, right? Okay, so we would argue that I have a legitimate expectation of privacy in her, because I gave it to her for safekeeping. Okay, now if I'm running from the police and I throw it, not so much. All right, does that make some sense? Okay, this is actually, I give an entire lecture on this for the lawyers, and at the end of it they say, could you give me an example? Do you have a follow-up question?
Well, would you have standing with yours? I cannot understand what the distinction between.
All right, so standing actually has a meaning. It's outside the search context. In order to sue someone, you need standing. You need to be actually hurt. And so there's a kind of a rough sense of what standing is. And you can make an argument that I don't have standing in her search because it's a search of her. Okay? Standing is not really a term of art. It's the shorthand word we use, and it's the wrong word. Because in the hypo I just gave you, I do have a legitimate expectation of privacy in the search of her search of my item that I gave her for safekeeping that horrible police officer sees. That makes some sense? So that's why I keep trying to say, stop using a term that we don't really know what it means exactly and we don't know how it applies, and it doesn't apply. The Supreme Court of the United States has said it's not, they specifically said not standing. Okay? Okay. All right? You can talk to me later if it's not clear. It's a lot of the legal stuff is just stuff that's just accrued over time. What can I say? Okay. That was legal. What's next? Oh, okay. So the next slide. It'll load, slow loading purpose. Okay, this is a very famous scene from a silent movie. Okay, I'm going to give a trivia win to someone who could name the actor on the clock. And if somebody actually knows the name of the movie, I'll fall down and I might have to give you extra prize. But let's just go for the name of the actor. Very famous silent movie actor. Way in the back. Say it. Harold Lloyd. That was very impressive. Man. That's very good. I thought it was Charlie Chaplin. I was doing searches for Charlie Chaplin. It's not Charlie Chaplin, it's Harold Lloyd. Do you know the name of the movie? Anybody?
I've seen it, but...
Yeah, I've seen it too, but I had to look it up. It's called, of course, Safety First. I'm sorry, Safety Last. Safety Last. I had a joke in my question. Okay, this is here for 352 of the Evidence Code. 352 of the Evidence Code is a code section that allows a judge to exclude otherwise relevant evidence because the evidence is confusing, prejudicial, or too time-consuming. See, clock. Okay. A lot of litigation goes on in 352 motions, and you'll hear we call them 352 motions. I'm making it 352 352 motion, I'm 352, they make it a verb, I'm 352ing out the thing, okay? So you'll hear this a lot, and it's a reference to this code section which deals with excluding otherwise relevant evidence. If it's not relevant evidence, we don't get the 352. But when we have 352, we're looking at, usually the defense is like it's too relevant, it's too prejudicial, okay? The 5 prior times he fondled somebody, okay? That might be a little prejudicial to the current fondling charge, whatever. Okay, that's kind of where we make. But it also could be undue consumption of time or confusion. Okay, next is, next we have a trivia. That's really, it's nice. Okay, next. All right, I want to know the name of the actor. Name of the actor. All right, let me try a different question. I'll give you a prize for this. Name of the sitcom. Don't yell at put your hand up. Name of the sitcom this guy's in. Well, don't yell. Don't yell. In the back, yes. Yes, Hogan's Heroes, and that gets a prize. Now, does anybody know the name of the? Oh, how about this? What character did this guy play in the show? I'll give you a prize for that. Name of the character. We'll get to the name of the actor. Okay, Ann, turn around. Ann, say. Colonel Klink. Okay. Name of the actor. Anybody got a shot at the name of the actor? Just died like last year. So great, fabulous character actor. Nobody knows? Okay. Well, this, ladies and gentlemen, is Werner Klemperer. Please remember him. And his most famous line in the show was next. Okay, I can't really do this justice, but it's like dismiss. I can't do it. The German accent is yummy. And let me just say this. I have an idea for a sitcom. How about a concentration camp, prisoner of war in Germany during World War II? That's almost as nutty as, how about a MASH unit at the front lines in Korea? Who's coming up with these sitcom ideas? Does these seem, I talk to my kids, they're like, you guys watched what? Okay? I don't know how to make these up, but okay. So this is 1385. Penal Code Section 1385, which gives a court a power to dismiss a case. And the court can dismiss it at arraignment, at the beginning, in the pre-trial, at the trial, after the trial, at any point in the case. The court can dismiss a case. There are a couple of restraints on judges. There are certain things they can't dismiss. 5-year priors can't be dismissed, whatever. But other than that, 1385 authorizes a court to dismiss a case, or any part of a case, an enhancement, a gang enhancement, whatever. And you'll hear people saying, I'm making a 1385 motion, this is 1385, judge, please exercise your discretion. Now, it's a little bit of a misnomer. The defense does not have a right to make a 1385 motion. The statute says, on motion of the DA, or the court on its own motion may dismiss a case. So we are in this weird posture of saying, Your Honor, we invite you to just exercise your judgment to dismiss the case on your own motion. We have an invitation. Okay? But you'll hear people refer to 1385. It's a motion to dismiss, essentially. Now, it's not a 995. A 995 is only available on insufficiency of the evidence or a legal error. 1385 can be, this is nonsense, I'm just going to dismiss the case. Okay? Next. All right. I'm looking for the name of the movie. Name of the movie. Don't yell. Be careful. Don't mutter. Walking Dead is not it. Walking Dead is not it. You want to go? Night of the Living Dead. Okay? And where are you? All right. Now, a second prize for anybody who knows the name of the filmmaker, pretty famous horror filmmaker. Kind of kickstarted the genre. Anybody know this name? Ooh, nobody knows the name. Don't yell it. Don't stop muttering. What is it? No. She tried one guess and she did. That feels good. Okay, anybody know? No, you gotta hit yourself when you see who this is. Nobody knows? Anybody knows? Say the name. Romero is correct. Give that man a little prize. George Romero. So, but Romero's what we're looking for. Next slide. So this is a Romero motion. That's not a picture. So the 3 strikes law came into effect, and there was a big debate about whether a court could get rid of a strike. Now we say, I hate this, strike the strike, which I think is confusing. Technically, it should be dismiss the strike, although I never heard anybody say that, but you hear him say strike the strike. I'm going to strike that strike. Okay? And it wasn't clear whether the court had the power. I just told you under 1385, courts have power. But the question was, did the court lose that power when the three strikes law passed? And in the case called Romero, the California Supreme Court said, no, courts retain the power to dismiss strikes. There are a lot of rules governing it. And the term we use is, I'm making a Romero motion, I'm going to get rid of that strike prior. Which makes, if it's the third strike case and it's 25 to life versus the second strike case and it's 8 years, that's kind of a big difference. Okay? So this is a really important issue in a lot of cases. The term is Romero motion, that's the term we use to refer to the motion to dismiss the strike priors. Okay, that makes sense? All right, next is, how many of you actually seen a drone strike? I never saw one, so I have a slide. Here it is. Like a second below.
Oh, wow.
I've never seen one. I was looking around, looking at strikes, I was looking at bowling and baseball. Okay, so advance, so we're not watching this anymore. Thanks. All right, so I just told you about getting rid of the strikes. What the hell's a strike? Okay, so the answer is, when the ball's over the plate between knees and letters, I'm really funny. I may not be there yet, but stay with me, okay? And in a criminal law context. So, the strike law defines strikes by lists. And there's two lists. There's a violent felony list, and it turns out everything on the violent felony list is on the other list, so I tell people don't even look at that list. The other list is the serious felony list, which I think is a very funny term. It's a serious felony, as opposed to those trivial ones. I mean, really? Okay? But it doesn't mean serious. There's a list. There's a whole list of things. Murder, rape, robbery, burglary of a house. There's a list. And there's conduct. Assault with a deadly weapon. Force likely use of great bodily injury. There's conduct stuff, too. And if something's on the list, it can be charged as a strike. If it's not on the list, it can't be a strike. And it's just a list. And those of you who are vernacular, that means 1192.7c of the Penal Code. 1192.7c has this list. And I get a lot of calls on, is this a strike? And I just take out my copy of 1192.7c and I look and say, yeah or no. That's all there is to it. It either is or isn't on the list. Now, there's lots of debate about proving strikes, and that's a lot of legal issues that we are not going to use.
So the strikes are the seriousness?
Okay, a strike prior is, or a current conviction that will result in a strike, is an offense which is on this list. It's on the Penal Code section 1192.7c is in cap list. It's just a list. And it's on the list or it's not on the list. Now, there's debate about it, of course. It can't be that clean. Okay, next. Here's the next trivia question. I want to know name of both actors and name of the movie that this is. Way in the back and the far right. Say it loud.
James Franco and Seth Rogen, and that's my
Wow, this guy knew it. So that's Frank on the left and Rogen on the right. Do I have that right? Okay. It's Pineapple Express. Next slide. And the reason for that is this is deferred entry of judgment. This is all about drug use. So, deferred entry of judgment is a diversion type statute in California. It's in Penal Code sections 1000 through 1000.8. And essentially, there's a list, another one of these lists, is a list of drug offenses, not all drug offenses, when selling cocaine is not on that list. Okay? So those of you who are thinking about doing it, you can't get DEJ. You might be able to retire as an interpreter, but you can't get DEJ. So the deferred entry of judgment, a defendant who's eligible for this because he or she has an offense on the list, pleads guilty. Now there's some criteria, there's some exclusions or whatever, there's a whole other lecture. But in theory, the person would then plead guilty to be diverted in effect. We call it pleading on DEJ. And then if they succeed, they come back, the case gets dismissed, and that results in dismissal. Now, you should know, and some of you may know my colleague, the fabulous and wonderful Graciela Martinez, who works with me in the appellate branch, who's our immigration specialist. There's lots of problems with DEJ and immigration issues. So the fact that it ultimately may be dismissed doesn't necessarily mean it's a good outcome, and that's a whole complicated area. So the lawyers know when they have these kinds of problems to be talking to my staff who are experts on these things. But DEJ gives people the opportunity to succeed. Now the next trivia question is kind of a cheat. Okay, go ahead. All right, so I want to know the name of the judge. This is not an actor. This is a real judge, and there's a cheat here because people may actually work in the building and therefore no judge. I didn't see a hand. You want to put your hand up? Yeah, go ahead.
Judge China?
Judge Van China, man, I don't even see you. Oh, you're to the right. Okay, that's Judge China. And when I put drug court in the picture in Google Images, I got a picture out of it with the gallows. But that's Judge China, who was a public defender at one time, and is now a judge and is famous for drug court. So drug court is pre-conviction. Remember, before entry of judgment, the person had to plead guilty. Drug court, they're not pleading guilty. It's pre-judgment, pre-plea. It's an intensified drug treatment program, which of course has had, every time we do a treatment program, it works, it saves money, it keeps people out of jail, and so then we lock more people out. I mean, it's like we finally figure out the fix, and then of course we do something for the country. All right, next. I want to know, this is 3 different booking pictures of the same gentleman. Anybody know who this is? Don't yell. Put your hand up if you know. Who is it? Who is it? Who is it? Wait. Yes, you. Okay, Robert Downey Jr.
Yeah.
3 different booking pictures. This is a bad sign. Okay, so Prop 36 is a drug treatment diversion type program enacted by initiative in 2001. It's another one of these words. So you can only get this for non-violent drug possession offenses. It turns out that it doesn't mean non-violent drug offenses. There's a list again. So when I did the training on this back in 2001, I realized people were very confused because they assumed it has to be non-violent drug. I mean, they assume that the term means something, and it doesn't. It's just like a serious penalty thing. So I came up with my own acronym on this, NOVIDPO, non-violent drug possession offense. NOVIDPO. Sounds like an Eastern European spy agency. We are from the NOVIDPO, you will confess later. Doesn't it? Anyway, if you hear somebody say NOVIDPO, you know that I did a training that they heard. But basically, this is Prop 36 is a program where people can, in effect, divert. They go into a treatment program. In theory, there's funding issues with that, and at the end, they get the case dismissed. Now, DEJ and 36 don't overlap perfectly. Sometimes there's a reason to do one or the other. Sometimes the person's eligible for one or the other. Sometimes they're eligible for both. There's some strategic considerations. Sometimes immigration issues on those. Okay, next. So this is Woody Allen, no credit for that. But I want to know, he's testifying pro per. That's what we're doing for others pro per. You're going to get a prize for the name of the movie this shot is from, one of his early movies. Anybody know this one? I know you know everything. Say it loud. Nope. Anybody else? If you just guess a movie. It's an old-time movie, but you got to say the name of the movie. You can't.
Small-time thieves or something.
Oh, Small-Time Thieves. No, I know what you mean. No, that's not it. That's it? Over there? Okay, I can't even see it. Go ahead. The light is not great, so I can't see that. Put your hand up again. Take Money Run is not it. Do you actually know the answer? Okay, say the answer. Bananas is correct. That man doesn't work. It's Bananas. And wait, do you know the name of the character he plays? Wait. I know you know. Does anybody else know the name of the character? Do you know the name? Say it. Fielding Knows. Give him 2 prizes. That was very impressive. I had to write it down on my piece of paper here because otherwise I couldn't get it. So this is, and this is a really, I have to say, really funny scene. Some of you hate Woody Allen, some of you don't. But Woody Allen, there's a trial where Woody's representing himself and he testifies. So he gets on the witness stand. He says, "Say your name, please." And he gets on the witness stand. He says, "Fielding Knows." And he gets off and he's like objecting to his own answers and gagging himself. It is a really funny visualization. So when a defendant represents himself or herself, pro per is the term, it's a Latin term. Remember, my second language is Latin. They're representing themselves. The case from the U.S. Supreme Court that said people could do this is called Feretta versus California. Interesting. So you'll hear people say, we get a Feretta motion. Well, that's a motion for the person to represent themselves. Okay? And that's the term you hear front of motion, and that's a reference to the case for it. Okay. All right, I got a trivia question. It's a music clue. I'm looking for the name of the performer, because you're not going to have any trouble with it. And all by me. Stand by me. It's going to be Stand by Council. That's right. Okay, name of the performer, though. And I can give you a short clip because otherwise I'd be dancing and you do not want to see that. Okay, name of the performer. In the back? I can't really see. Okay, over here. Yeah.
Benny King.
Benny King! Give that man a prize! Woo! Next slide. Did we say Benny King, but it's Ben E. King? Okay? So this is standby counsel. So these concepts are very poorly understood. We're going to cover advisory counsel next. Very poorly understood by everybody, especially the judges and the DAs and the defense lawyers. So standby counsel is a pro per defendant, a Feretta motion granted defendant. It's a lawyer to stand by in case the court revokes the defendant's pro per status. So the lawyer's like sort of, I was going to say designated hitter, but not even that, because designated hitters get the hit. This is the guy in the dugout. And then, he sits there, and then, at any moment he might be called on to jump in and take over the case, because otherwise a mistrial would have to be declared. A lot of the pro pers get their status revoked, and then the case is a mess. So instead of that, they appoint someone standby counsel. My office will not do standby counsel, nor will alternate public defendant. But obviously we need to do it sometimes. It's just my office one. Now the next one's advisory counsel. I have, I think, a cute graphic for this. Let's see what you think. It takes a second to load. So this is Lucy giving advice for a nickel, right? From Peanuts, one of my favorite all-time cartoons. So advisory counsel is counsel appointed on behalf of the pro per defendant to actually assist the pro per defendant during trial. So like co-counsel. So the advisory counsel sitting there going, object to that. Plead guilty. Stuff like that. So that's the difference between standby and advisory. These are very poorly understood and people mix them up all the time. So I'm giving you what the correct answer is. Okay, next, I want to know the name of this person. Name of this person. Who knows the name of this person? Yep, Carmen Miranda. And you'll never guess what we're going to cover next. Yes, Carmen. Carmen! Okay, next slide. Okay, I think there's just a blank slide. Let me double check. Yeah, okay. So you all know Miranda. When the guy's arrested, they have to advise the guy's Miranda rights. We see this on CSI and all the horrible shows I can't stand to watch because somehow the defense is always the bad guy. Okay, we're not going to cover Miranda, but there are many aspects of Miranda that may come up during a hearing on a claimed Miranda violation. We're going to talk about some of those. The first is a trivia question. Right? Who's this? Who is this gentleman? I'm standing right in your line of sight. I'm sorry. Who is this? Who is this? You need to be a little bit older because you young folks have no idea. He invented Jeopardy and Wheel of Fortune. It was a talk show host. Okay, yeah. Merv Griffin. And I hope you can make it all the way over there to give the prize. Next slide. Well, this is like 1954, I don't know, he's really pretty young. So there's a concept, a Miranda-related concept called Griffin error. So Griffin error, this is not directly Miranda. This is when a prosecutor comments during final argument on the defendant's failure to testify. So we call that Griffin error. We'll say, I'm not Griffin error. It'll be like, Griffin, aren't you Griffin? Griffin. Okay. Next. Doyle. So if we're going to talk about Doyle, we're going to talk about Arthur Conan Doyle. If we're going to talk about Arthur Conan Doyle, we're going to talk about Sherlock Holmes. If we're going to talk about Sherlock Holmes, we're going to look at various actors who have played Sherlock Holmes, recently and not. All right? 3 wins possible here. Come on. Some of you must be going into sugar shock. It's been like an hour since you were eating. You need some candy right this very minute, or at least a toy to entertain you. Okay? Going to be 3 actors. Okay? Here's the first one. This one should be pretty easy. He looks completely different. Okay, back here, yes? Robert Downey Jr. And get on your track shoes. Next. Ha! How about that one? Not very recent. Do you know? Basil Rathbone. Yes, very good. Next is my favorite television show at the moment. I'm looking for the gentleman on the left. You I'm gonna have to look at you a little, because you can't win everything, okay? Somebody must know who this is, in the back right. Benedict Cumberbatch. And now, the new term, I didn't invent the term, but for gals who really like him, is cumber bitches. I'm just saying, I didn't invent it, I'm just reporting it. That's the term I'm hearing. This is my favorite television show, Sherlock, out of BBC. They only do 3 or 4 episodes a year. There's a new one in the pipeline, though, and it won an Emmy this year. One of the shows won an Emmy. I like this very much. So, hold it here. The reason this is up here is it gave me a good excuse to show lots of different actors. But there's a case called Doyle versus Ohio. So, when a defendant is advised of Miranda and makes no statement, so you have the right to remain silent, you wish to speak. And you know, I've heard a common routine on this. Okay? So, you have the right to remain silent. Anything you say can be used against you in a court of law. The right to attorney, if you can't afford one, will require for you. Do you understand these rights? No. You just told me. Right? You see the dilemma? It's an interesting dilemma. Okay. It's funnier with the comment. Can the prosecution use the fact that the defendant didn't say anything? Now, we just talked about Griffin, which is commenting on the defendant's failure to testify at trial. Okay, Doyle is commenting on the defendant's not responding to Miranda when Miranda is given. And Doyle versus Ohio, 1976, U.S. Supreme Court case, says misconduct for the prosecutor to use the defendant's silence. Well, why wouldn't he say he didn't do it? Ladies and gentlemen, the jury. That's misconduct. It's called Doyle error. Okay? Or Cumberbatch error. I'm not sure which. Okay, next is Messiah. I have a little stitches get stitches. It's going to get you. So Messiah is a 1964 case where the police put a snitch in a jail cell with the defendant to try to get him to make statements. Now, they can do that before the case is filed, before the charges are filed. But once they're filed, this is a little bit complicated, but usually once the case, they've had an arraignment, they've got a lawyer, at that point, trying to get statements from the defendant is unconstitutional under Messiah. And you'll hear people say Messiah violation, making a Messiah motion. Okay, another trivia question. I saw this guy interviewed last night on Trevor Noah's Monday show. Okay, name of the actor. He's on he's on Westworld, doing Westworld HBO show. Ooh, maybe they don't know. He's pretty famous. Okay, back right. James Marsden. Very good. Next time. Okay, so you'll hear people talk about Marsden motions. Okay, so there's a case called Marsden. So sometimes you'll be stunned to hear this. You won't believe this. Sometimes the defense lawyer and the defendant do not get along. Hard to believe. And it gets worse and worse. Now, sometimes the defendant's mental, the defendant's unreasonable, but sometimes the lawyer's mental, the lawyer's unreasonable. And I'm not saying it's one way here. The defendant has a right to make a motion, essentially to get rid of the lawyer and replace the lawyer with another lawyer. So we call this a Marsden motion. Now, in my office, when occasionally a judge grants that motion, we don't send a different lawyer in. Some other office has to handle it. I don't think they handle it. They just send a private lawyer. And in my experience, about a day later, the client's like, can I have the piggy back? This guy is crazy, crazier than me. Okay, but the motion the defendant makes to get rid of his lawyer for irreconcilable differences, sounds like a divorce, doesn't it? And it kind of is a Marsden motion. So you'll hear the lawyer say, well, if you feel that way, we're going to make a Marsden motion, you can tell the judge what the problem is. Or the defendant might say, I want my Marsden motion. Okay? And it's a reference to James Marsden. No, it's a reference to this case. Okay. All right, so the next, I'm going to show you a movie clip. I'm looking for the name of the movie. Okay, go ahead.
I said I want the truth. You can't handle the truth. I said I want the truth. You can't handle the truth.
Name of the movie, back middle. Go ahead. A Few Good Men. Okay, I wasn't going to do Jack Nicholson. I said you don't know Jack Nicholson. But this is a famous clip from A Few Good Men. And this is relevant to Prop 8, which was an initiative passed in 1982 called the Truth in Evidence. It'll get funny. Just stay with me. It'll get funny. So, I give entire lectures on Prop 8, longer than this lecture. There are a lot of things in Prop 8 still being litigated. The key thing is no relevant evidence shall be excluded, so that's why it's called the Truth in Evidence provision. There'll there were a lot of changes, including limitation of plea bargaining, and this is the initiative that created that list, the serious felony list. This is long before strike stuff. Okay? Now next, I have a rock group to show you. Go ahead. So this is a British pop group called Hearsay. Anybody heard of this group? I have never heard of this group. I actually kind of like the track, which might be a bad sign. But again, international music, okay? Now the reason it's up here is Prop 115. Prop 115 is yet another initiative. This is 1990. Making a whole bunch of other changes in the criminal justice system. One of them was discovery from the defense, which had been barred up to that time. We're still litigating that. But the other is, and the one that you probably have the most contact with, is preliminary hearings. It authorized admission of certain kinds of hearsay at a preliminary hearing. Now, there are rules governing it, but you'll hear people say it's a Prop 115 prelude. And that's a reference to a preliminary hearing where hearsay was offered. So you'll hear the reference, but they're not really explaining why they're calling it that. Okay? We're going through lots of propositions. Okay, here's the next one. I want to know. I'm afraid nobody will know the name of the movie. Let me give a prize for the name of the actor. Let's start with that. Hopefully somebody knows that. Yep, on the right. Say it loud. Kevin Spacey and where's Anne? I can't see Anne. And take the candy alone.
She left with the candy.
No, there she is.
And did you see that this gentleman over here has candy? I can't see the back of it. Okay. Anybody know the name of the movie? I'll give you a separate win for that. Anybody know the name of the movie? This is a shocking movie. We're right next to it. Go ahead, yell. 21. Give that gentleman a prize. That's good. I didn't think I was going to get that. Okay. So this is Prop 21. Ha! Prop 21 is a 2000 initiative. Making more changes in the criminal justice system. The big one is direct file juveniles. And on the ballot next month is a initiative that will repeal the direct file for juveniles. Direct file means they don't have to file in juvenile court, they can file directly in adult court. You may know that in juvenile court they can file and ask for the minor to be found unfit and sent to adult court. Prop 21 allowed direct file, and there's an attempt to change that. Okay? Next, Prop 47. Well, we're spending a lot of time on these things, okay? So, Prop 47, we spent a lot of time on. I have a slide. A lot of people ask me to explain Prop 47. I give training talks to lawyers. I can do the whole talk in one slide. Here it is. A lot of felonies, next, are now, next, misdemeanors. A lot of low-level felonies, theft and drug offense felonies, are now misdemeanors. Now, I do an hour and a half talk on all the intricacies involved in Prop 47. But really, that's what it boils down to. The 2014 initiative, changing a lot of stuff. Okay, next. I want to know the name of the actor. Name of the actor, name of the actor, name of the actor. Name of the actor. And back, yes. Say it. No, we weren't guessing. We're just stretching. Okay. Don't wave your hands. Nobody knows who the actor is, really? Well, don't just yell it. Put your hand up so you win a prize.
Jim Carrey.
Okay, who said it? Raise your hand. Okay, I can't see you. Okay, it's Jim Carrey, and it's anybody know the name of the movie? Okay, we're here. No, that is not this movie. That is a movie, but it's not this movie. Oh, you want to do again? No. Anybody know? Over here. Say it again. Lemony Snicket. Okay. So this is in limine, it's a Latin term, and it refers to evidence code section 402, which is a motion usually made by the defense, although sometimes the prosecutor makes it, pre-trial, to admit or exclude a piece of evidence. The mechanism for the procedure is covered by evidence code section 402, and it's referred to, you'll hear us say 402 motion, but you'll also hear us say in limine, they are the same thing. Okay, next. Non-proton. Remember, I took all that. I took 5 years of Latin. So this is a candy bar now for later. Non-proton is Latin for now, for then. And what happens is the court corrects an order that was made sometime previously. So it's called non-proton. It's fixing a mistake that was made previously in theory. Okay. Next, and GI. Oh, I have a trivia question. Who is this? you, go ahead. Cypress Hill, cheese. That's awfully fast. Okay, Cypress Hill, did you see it? Okay. So this is NGI Insanity, ladies and gentlemen. It's crazy time. So I talked earlier about a defendant who was not competent to stand trial today. The defendant can be competent or not competent, but he also could have been insane or not insane at the time of the crime. NGI is not guilty by reason of insanity, meaning he was insane at the time of the crime. Not now, but then. He can be both, neither, one, the other, whatever. There's there's obviously a lot of overlap, but there's nothing necessarily true about it. So we say NGI means not guilty by reason of insanity. Okay. Corpus delicti is next. Now, I had a sound clip from this group that was so horrible, I refused to play it. So you'll hear this term, corpus delicti. It is Latin. And it's body of the crime. That's what it means. And it's the elements of the crime apart from the identity of the perpetrator. So a defendant can't be convicted of a crime for which the defendant confessed if there's no evidence that a crime actually happened. Okay? And you'll hear the term corpus delicti. Okay, next, I'm just going to bet. I have a stealth plane here. Let's watch it. And I have a comment. If they're secret stealth planes, how come we can see them? But anyways, what a stealth fighter looks like. Next slide. Now, I want you to be honest, no prize. I want you to be honest. Has anybody in this room heard the term stealth wobbler ever? Let me see hands. Anybody? Yeah. Okay. Well, it's a term. And there's a case on it. And the term means, you know that a wobbler is normally an alternate felony misdemeanor. Okay? So a stealth wobbler is a crime punishable by prison or a fine. Prison or a fine. Called a stealth wobbler. There's a case that says it. Okay, next, pitches motions. The officer says, I'm going to kick your ass in the way with it. Okay, pitches motion is a motion based on the pitches case for discovery of police complaints made against police officers by citizens. We're trying to get a discovery of those complaints because we could maybe use them in the current case to show police misconduct in some kind. All right, here's your first trivia. Getting toward the end of the trivia, okay? Your hint is villa, that's all I'm going to tell you. And I'll pretty much give a prize for any, if you can give me the name of the character, the name of the actress, anything about this person. Anybody, any Harry Potter fans here? It's a Harry Potter thing. No, really? My law clerks are like, nobody's going to have trouble with this. They're all going to know who this is. No, no one knows. You got a big hint on the screen. Okay, so the room doesn't know. Okay. I'm sorry, what? Somebody has their hand up? Wait, okay, I can't see the background. Go ahead. Okay, I can't. It's Clemence Bossy. That's the one thing I thought nobody would guess was the name of the actress. Give that person a prize. Do you know the name of the character she's playing here? It's Fleur de la Cour. Now, this is the one my law clerk knew. What kind of being is she? Anybody know this? Being, B-E-I-N-G, being. What kind of? She's not human. Not exactly. Anybody know this? All right, she's half Vila. The Vila are a race of semi-human, semi-magical humanoids. But it perfectly matches Vela. So you'll hear Vela motion. The Vela motion is a motion for discovery of a police investigation of the crime that's being charged today. That's what a Vela motion is. Next, anybody know who this is? Anybody? Okay, go ahead. It's Tom Brady and.
Tom Brady, raise your hand.
Because we're going to cover Brady motions. Now I have a second part of the trivia question. Yes. His girlfriend now what? Next slide. Anybody know her name? How about that? Get the model here. Do you know? Say it loud. You said probably better than I can say it. Giselle Bundchen. And we have another winner up here. Running. So this is Brady violation, or Brady motion. So the prosecution has a duty to disclose to the defense exculpatory evidence, even without a request, and a violation of that duty is called a Brady violation, a Brady motion. Brady motion to establish a Brady violation. Okay, next, we're running out of time and we're running out of trivia, so I'm going to give out lots for the next one. This is a movie called Youngblood. It's a 1986 movie, and it starred a lot of people who became very famous. So I'll give you two if you can guess. Two different prizes here, okay? So the guy on the left, anybody know the guy on the left? Everybody, yes? Rob Lowe, and the guy on the right, now come on. Okay, not you, the other way. Go ahead, say it. Patrick Swayze. Okay, Keanu Reeves was in this movie too, he didn't make the poster, okay? So you'll hear Trombetta Youngblood motion. A Trombetta Youngblood motion is a motion where the prosecution has destroyed evidence usually, or failed to collect it, usually destruction of evidence. Where the defense makes a motion to dismiss, usually we don't get a motion to dismissal, we get a jury instruction or something that's not quite as helpful as we would have liked. Okay. Next, and I'm really going to be impressed if anybody knows this. This is Murguia National Park. I'm going to give a prize if somebody can tell me this is not in the United States. If you can tell me what country this is. Just a country. Anybody? Put up your hand. I can say it loud, I can hear you. No, not Spain. Not Ireland. Italy. Who said Italy? That's the right answer. So is a park in Italy. This is a Murguia motion. A Murguia motion is a motion challenging discriminatory enforcement of the law. Okay? Next, Evans. Oh. You're going to still have to hear it. Here's a good lineup. What? What? So when the defense wants itself to have a lineup, we want to put a lineup together. We have to have the police have to do it. We make a motion for a defense lineup. It's called an Evans lineup. Okay. Now next, we're going to hear the music. I want to know who's singing. Who is singing? You got it. Say it loud. Crawford is good enough. It is Michael Crawford next time. Because we're going to go with Crawford. Crawford is a case in 2004 barring admission of testimonial hearsay unless the witness testifies. And there's lots of litigation with Crawford. You'll hear Crawford motions. All right, here's next. I'll be very impressed if you know who this is.
But I never want to see you satisfied. Are you satisfied?
Anybody know who it is? No. Do you know him? No, not Guns N' Roses. All right. So this is next slide. Aranda. How would you not know Aranda? I never heard of her. They're Oklahoma brothers, Damon and Greg Aranda. This is Aranda Bruton. So Aranda Bruton is the cases that bar use of a co-defendant's confession implicating the defendant where the co-defendant does not testify. Now they can try to redact the statement, but when they can't, Aranda Bruton is the authority that you'll see cited. Okay, next is Batson Wheeler. Batson Wheeler are the cases that bar either side. We always think about the DA, but the rule applies to the defense as well. From kicking off jurors on what are called cognizable groups, which is essentially racial, kicking off African Americans, kicking off women, kicking off groups of people from juries. That's a Batson Wheeler violation. Next, Boycott. Now I drove here this morning, I took the freeway, but I often drive down Sunset, and there's a time travel bar on Sunset. I don't know if any of you have checked this out. I have. It's bogus. But this is Boycott. Boycott is an attempt to knock out a prior. You see, you go back in time and try to invalidate a prior. Often done in drunk driving cases where we're trying to get rid of the prior because of misadvisement, basically, or failure to advise correctly on the prior. Next. Oh, wait. Don't change. I have a trivia question. I just came up with this yesterday. Sean Hannity, Fox News, has accused another Fox News reporter of being a secret supporter of Hillary Clinton. Anybody know who that is? Who the person he says is the secret supporter? Anybody know? There's not that many Fox News. No. Who said Megyn Kelly back? Stop yelling. Put up your hands. And that person gets away. Next slide. It's Megyn Kelly. And we're going to talk about Kelly Fry, which is the rule governing admission of scientific evidence. To get scientific evidence into evidence, the proponent, usually the DA, but sometimes us, established that it's reliable and accepted in the community. It's called Kelly Fry. Actually, Fry is a bit of a rule, but we still call it Kelly Fry. Okay, next. This is a guy saying, Your Honor, my client would like to waive his right to a speedy trial. His client is a juror. So this is 1382. 1382 is the penal code section that provides for speedy trial. It has the time limits for when stuff has to go to trial. Okay, next, trivia question. This is the last trivia question. What group? What's the group you're looking at?
The Beach Boys.
Not the Beach Boys. Look at them, they're not the Beach Boys. There's 5 Beach Boys. Okay, everybody know who this is? No? No? Okay, so this group in the 60s. So these are the Ventures. And they had a hit with an instrumental song with that opening. Right now, 203.4, misnamed expungement. It is not expungement. Not expungement. We say it all the time, it's not. 203.4 is a dismissal. It has certain requirements, it has certain benefits. It's not literally an expungement. Expungement would delete it from the record, it does not delete it. Okay? We spend all of our time trying to correct that. Next, Deuce. So I have Deuce Bigelow, a male gigolo. Anybody ever seen this movie? It seemed like a horrible movie, but whatever. You don't get a prize for having seen the movie. You get like the bonuses, I think. So Deuce is the word we use for drunk driving, driving under the influence. And it has a long origin, which I'd like to tell you, but I'm running out of time. So I'll just tell you that the code section used to have a 2 at the end, 602, and so they call it deuce because it's 2. See how funny that is? Okay, that's how much it is. Next is 1:08, and one of my colleagues' teenage son came up with this visual, which I thought was quite striking. 0.08, an 8 ball with a 0, isn't that great? 0.08 in a drunk driving case, if the person took a test and the test is a 0.08 or above, that can be a second charge, a second count. So we often see drunk driving cases with 2 counts, one driving under the influence, and the second is the 08 count. And they'll be, I'm pleading the 08 count, or they can't make the 08 count. And the 08 count is that charge, which is that the person got a reading of above 0.08. Okay, and the very last one, the whole talk, is pass, as opposed to fail. Seriously, this is the preliminary alcohol screening test. So when the police stop you leaving the Biltmore because you're leaving and drunk, there's a bar here, and they take you out of the car and you're staggering around, and they give you the feel sobriety test, which you found, and they give this thing. It looks like he's playing a horn. You blow into it, and it gives them a preliminary test. Now, some courts try to admit this evidence. There's a lot of controversy over the admission of this piece of evidence. But it is a field test that the police use. You know, one of the arguments, I don't want to go off on a tangent here, one of the arguments made against the marijuana initiative is that it's hard for the police they don't have a pass for marijuana, which, you know, it's certainly a good reason not to legalize something that's, you know, a lot of people are in prison for having something grow in your backyard. I don't want to get off on a tangent, but I'm just saying it's very controversial. Okay, that's it. So, you guys like that? Was that fun? Did you learn enough stuff?